Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you about what happened to administrative closure in immigration courts. What happened is that Attorney General Jeff Sessions decided that administrative closure should not be as widely used in immigration courts as it was in the past. As you're probably aware, a case in immigration court can be closed by various means. It can be resolved on merits, or it can be terminated, or it can be administratively closed. Courts very often use administrative closure to put a case on pause and allow USCIS to resolve certain applications, and then the individual would come back to court and would ask the case to be terminated, so an individual would be able to proceed with his or her case with USCIS rather than an immigration court. Sometimes administrative closure was used because at a particular moment an individual would not qualify for relief, but the judge would give an individual time for his or her case to get ripe, and the individual would be able to qualify for relief later. So I guess Attorney General did not like that and ruled that courts should not be used administrative closure in almost all cases where it was used before. There are, however, some cases where administrative closure is still appropriate because it's specifically provided as a method of dealing with cases in certain regulations. For example, for NACARA applicants, of course, nowadays, very little group of individuals will still qualify for that relief, but for them, the court there is specific regulations saying that their cases should be administratively closed under certain conditions. Also, for those individuals who are looking for V visa, T visa, administrative closure is still appropriate. What's bad about the Jeff Sessions decision is that in it, it says that prosecutors can move to recalendar cases that were administratively closed. So, in theory, individuals with administratively closed cases may receive new notices to appear, new hearing notices, and will have to appear in court. And if by then their case is not ripe to be resolved by the court, I guess they will have no choice but to ask for an adjournment, to postpone their case. So what can you still do if your case is most appropriate for administrative closure, but now it seems that it's out of the picture? Well, first of all, termination is still available, even though judges, of course, will be reluctant to terminate cases. They cannot administratively close cases, and of course they will be reluctant to terminate. But for good cause shown, you still can move to terminate the case. In other situations, you will have no choice but to ask for continuance or adjournment to postpone your case. Let's say there is I-130 that is pending and it needs to be resolved before you can file for adjustment of status. Or it's a siege case that's pending and I-360 needs to be resolved, or in many other cases. You may also ask to dismiss the case in certain situations when the charges are defective, or there is a defective notice to appear, charging document. But that's about all the remedies that will be available to you. I have to say that most of the judges will be sensitive to this issue. And I know in New York, for example, there are special dockets that allow to move cases from active docket to like a sleeping docket that will, where you need an attorney will have to provide the court with updates as how the case is moving, and based on that, the judge will decide when to recalendar the case. But that's where we stand right now. So if you were counting on administrative closure for your case, now you may want to rethink what you're going to be doing in court and come up with a different strategy. And you can read more about this on my website, www.shautsova.com. Thank you.